The rearrangement of chairs takes a little time. We are in the hands of our
Yes.
of our ushers.
Yes. But I was taking your lordship's lord through the act, and from my
Yes.
lord the Chief Justice, my lord, it rightly fell. This is an act of licensing era where there was too much of red tapeism, etc., etc. And now the country has progressed. So before I complete that act, my lord, I reached up to section 11. Now I am going to show only 5 or 6 other sections, my lord, not the entire act. My lord, I would wish, my lord, subject to your lordship's approval, to show, my lord, why this act is still relevant and why it is kept. Lord, 1991 is the year in which, my lord, we shifted as a nation from, my lord, old licensing regime to pre-economy regime. So that, my lord, I have given in volume 4G at page 385. Only few paragraphs, my lord. This was when, just, my lord, by way of information, Narasimha Raoji was the Prime Minister and Dr. Manmohan Singh was the Finance Minister. They pioneered, my lord, this new industrial policy. But please come to para 7. I'll read only relevant part, my lord. Page 385, my lord.
Which volume 3?
4G.
4G.
Roman 4, capital G. Why this act is still relevant, why it is consciously not either amended or repealed, and why it would be necessary, my lord, for your lordships to examine it in that context, that in future, even present, it is implemented and it needs to be implemented, maybe, my lord, depending upon the circumstances. From para 3 to 6, earlier policies are dealt with. I am not, my lord, taking your lordships. Para 7 of, my lord, this is industrial policy dated July 1991. Para 7, the policies created a climate for rapid industrial growth in the country. That is earlier policies. Thus, on the eve of the 7th 5-year plan, a broad-based infrastructure had been built up. Basic industries had been established. A high degree of self-reliance in a large number of items, raw materials, intermediates, finished goods had been achieved. New growth centers of industrial activity has emerged and has new generation of entrepreneurs. A large number of engineers, technicians and skilled workers had also been trained. Now, my lord, kindly, my lord, see the next page. It demarcates in 4 categories, my lord. In para 19, my lord. In pursuit of the above objective, the government has decided to take a series of initiatives in respect of policies relating to the following areas: industrial licensing, foreign investment, foreign technology agreements, public sector policy, MRTPA. Lord, we are concerned with the first only, my lord. Please see, my lord, industrial licensing policy. Industrial licensing policy, licensing is governed by the Industries Development and Regulation Act 1951. The Industrial Policy Resolution of 1956 identified the following 3 categories of industries: those that would be reserved for development in public sector, those that would be permitted for development through private enterprise with or without state participation, and those in which investment initiatives would ordinarily emanate from private entrepreneurs. Over the years, keeping in view the changing industrial score seen in the country, the policy has undergone modifications. Industrial licensing policy and procedures have also been liberalized from time to time. A full realization of the industrial potential of the country calls for continuation of the process of change. Not para 22 thereafter, your lordships may skip 21. The winds of change have been with us for some time. The industrial licensing system has been gradually moving away from concept of capacity licensing. The system of reservation for public sector undertaking has been evolving towards an ethos of greater flexibility, and private sector enterprise has been gradually allowed to enter into many of these areas uh, of a case of caste basis. Sorry, ma'am. On case-to-case basis. Further, impetus must be provided to these changes, which alone can push this country towards the attainment of its entrepreneurial and industrial potential. This called for bold and imaginative decisions designed to remove restraints on capacity creation, while at the same time ensuring the overriding national interests are not jeopardized. So thereafter, your lordships may kindly come to Lord Para 39, my lord, page 389. Lord, I am skipping what is not relevant for the IRDA purpose, because they made several changes in foreign direct investment, etc., etc. And MRTP Act was, my lord, mark one thing, MRTP Act was substantially amended to bring it in tune with the new regime of liberalization. I say this, the government thereafter consciously neither repealed the IDRA nor amended IDRA. And I'll point out, my lord, why.
But Solicitor, you are relying upon this 1991 today. It looks very primitive. So much has changed now. Today, you are relying upon 91 policy.
I'm not relying upon. I'm sorry. I'm not relying upon.
Right.
I am. This can't be relied upon.
Respond to what Honorable Chief Justice of India said. I mean, this policy in today's context.
Kindly allow me.
Right.
I am not justifying the act based on this policy. It's a 91 policy, years back. My purpose is to show that the changes, winds of change, as they say, is taken note of. There are certain changes made. The IRDA is taken note of. Look, this is the policy which de-licensed everything, except some items. I am not saying that I justify IRDA. I am not supposed to justify, because that's not under challenge, but that's a very basic argument. I am just saying that this was a event which changed the course of our economic history. But still, IRDA was neither amended nor repealed. And after at the end of this, I'll be able to show why I am showing this, not to rely upon it, to justify existence of IRDA, to point out to your lordships that it is still in operation, and in future it can still be required to be utilized by the country, and therefore consciously it was not done. As my lord, the Chief Justice of India, my lord, was pleased to say that now we are in a de-licensed era. That is true. From 91, we are in a de-licensed era. And the provisions which I read provided for licensing. But some scheduled industries are still under licensing regime. And I will be able to show in future, if the circumstances or contingencies so demand, the country may need again to control them. And I will give the illustrations. Lord, Para 39, decisions of the government. Lord, kindly see A, industrial licensing policy. Industrial licensing will be abolished for all projects except for a short list of industries related to security and strategic concerns, social reasons, hazardous chemicals, and overriding environmental reasons, and items of elitist consumption, that is list at annexure 2. Your lordships need not go it right now, because that also has kept on being amended. I'll point out what remains in the schedule as on date. Now your lordships, my lord, kindly turn to annexure 2, my lord, just to have a flavor, my lord. 392, my lord. Since this case incidentally concerns alcohol, but as I have pointed out, My effort, my lord, is not. Lord, let me, my lord, make this again clear. Lord, my effort is not to succeed in case of alcohol. That alcohol only center has the power under entry 52. Lord, entry 52 encompasses several things. And therefore, my lord, your lordships in this combination are examining the question of law. Therefore, my lord, must point out from a broader perspective than just alcohol. Because that happens to be the case here, the fact situation, but your lordship's law would apply across all industries. Lord, distillation and brewing of alcohol was still under the licensing regime. Now it is not, I must say, but it was not at the relevant point of time. Now your lordships may kindly see what is the present position. List annexure 2 constantly became shrinking. It remains shrinking. My lord, more and
Where
more.
did we get the latest position, Solicitor?
Yes, my lord, we have uploaded it, but it has not reached your lordships. My lord, it's only one page.
It will not be in this act.
It's not in this act. My lord, it's one page. My lord, if I can request
Yes, certainly.
4I. 4I, page 23. Now the Act, my lord, controls, regulates, or provides for licensing of these products as on date.
4I.
For my lord, only completing the record, Section 29, capital B of IDRA provides or empowers the central government to exempt certain industries. Your lordship did not go into
29B.
29 capital B, under which, my lord, several industries were, my lord, removed from list schedule 2.
Why?
So the effect of 29B is it remains in the schedule to the Act, meaning thereby it can always be brought under regulation. But for the time being, it would be exempted from the provisions or the regime or the licensing policies, etc., under the IDRA. So potential regulation remains. So, your lordship have page 23. It would be here, my lord. My apologies, my lord. It would be displayed, my lord.
Yeah, but it's now there's a press note number 3.
Yes, 3, my lord. The press note number 17, series regarding environmental clearance of industrial license conditions of letter of intent industrial license relates to pre-1991 period. After the Industrial Policy Resolution 91 and considering various amendments made to notification number so and so, only the following 4 industries are covered under the compulsory licenses: cigars and cigarettes of tobacco and manufactured tobacco substitutes, electronic, aerospace and defense equipment, industrial explosives and hazardous chemicals. These are, Lord, now under licensing regime. The entire Act applies to them. Rest of the industries are as on date out of it. Kindly bear one factor in mind. 91 policy delicensed everything. Thereafter, my lord, except for the rest of the industries were exempted from the licensing regime. But they continued in the schedule very consciously.
Schedule is not amended.
Not amended. MRTP Act, my lord, there is a discussion, my lord, in 1991 policy itself, that now we will have to bring it in tune with this liberalized regime. We also amend the MRTP Act, but this act is not even amended, and there is a reason why.
You are trying to say that following the liberalization regime that we entered into on the licensed judge, the government of India is consciously taking certain steps. And the press note that you are pointing out is that only now these 4 categories of industries are within the licensed judge.
Correct.
But we are keeping the industries mentioned in the schedule to the act, so that at a given moment, if we have to do something, we'll bring them within. But then the context, if you look at also 20B, which is the empowering, there also you have to do it on the exigencies or the contingencies that are mentioned in 29B.
No, my lord. Kindly, I also, my lord, your lordships are right. My lord, I also initially read it like it, and that may be a correct reading. But thereafter, my lord, I change my interpretation. My lord, that is only for one category. Please, my lord, read 29B.
Yes.
If the central government is of the opinion, having regard to the smallness of the number of workers employed, or to the amount invested in any industrial undertaking, or to the desirability of encouraging small undertakings generally. Well, this is first part.
Yes.
Or to the stage of development of any scheduled industry. This is second part, which applies to the first 3 contingencies are for small industries. For other scheduled industries, stage of development of the scheduled industry, that it would not be in public interest to apply all or any of the provisions of this act thereto. It may by notification in the official gazette exempt, subject to such conditions as it may think fit to impose, etc., etc. So, my lord, first 3 is for small industries. The rest is, for example, non-potable alcohol is still in the schedule. My lord. No, nobody disputes that fact.
It's not regulated by the act.
It's not regulated by the act. As it stands today, it's not regulated by the act. So we have a particular quantity of non-potable alcohol which is produced. Now, non-potable alcohol has several uses. I'm just giving a hypothetical example why the act still retains the power to regulate in future. It goes into making of the potable alcohol. It goes into making of certain medicinal preparations. It goes into making of certain paints and other industrial uses, my lord. Now, my lord, we had COVID, for example. And we require, and the government of India, the nation requires, that entire quantity of industrial alcohol should be used only for manufacturing sanitizers, for example, giving a hypothetical example. Then the government can again utilize the regulatory power. Therefore, the power is retained, the regime of forbearance is enforced. That we will forbear from exercising. But the power is there, and not a decision not to exercise the power is also a decision. But I have given 2 examples in my original note, my lord, if your lordships can come to 2D, my original note, just to, my lord, illustrate this point. Page 56 of my note, my lord, volume 4D, 2D, I'm sorry, volume 2D. So these are the figures taken from the Niti Aayog roadmap. The Niti Aayog conducts that what is the requirement of the country qua each schedule industry, product of each schedule industry, whether that requirement is met, if not met, what steps are to be taken. My lord, everything, my lord, since decades, everything happens very scientifically. There is a system in place. The country, my lord, doesn't run on an ad hoc basis. There are systems, there are institutions, every institution functions, they have their own defined roles, etc. Please see, my lord, page 55 first. What is the position of alcohol? This is what the Niti Aayog would examine. Your Lordship have the chart, my lord. Just I am illustrating, my lord. This is by way of an illustration. My lord, 21-22, the ethanol requirement, my lord, for blending was 437 crores. My lord, page 55, 2D, volume 2D. For blending, requirement was 437 crores. And for other uses, that is potable, my lord, making beverages plus industrial alcohol, it was 270 crore liters. So the total requirement was 707. The country was meeting with that requirement, therefore regulation was not necessary. But suddenly suppose there is a spike in the use of alcohol, not potable alcohol, but for use of any other alcohol, then possibly, my lord, the central government can step in and say that now we will control what will be produced, license will have to be required, from where you will procure the raw material. The raw material also may be required to be diverted. That sugar cane becomes molasses and molasses becomes ultimately the alcohol. So sugar cane would not be diverted for manufacturing sugar. It should be used for only manufacturing alcohol in a given set of circumstances. Therefore, the law is right now exempting most of the items. So similarly, my lord, please come to the next page, my lord. Lord, this is regarding the sugar. The sugar is an essential element, as an essential food item, my lord. Please see, my lord, sugar cane production vis-a-vis sugar production and sugar consumption. Kindly, my lord, have a look at page 56. Lord, sugar cane production is this is in lakhs metric ton. In 1819, sugar cane production is 4054. Now, sugar is produced is 332 metric ton, lakhs metric ton, and the consumption is less than this. Now, suppose, my lord, for whatever reasons, international reasons or national reasons or whatever reasons, there is sudden decrease in the sugar production. And the nation needs uniform availability of sugar at uniform prices. Then, my lord, sugar remains in the schedule, right now under the forbearance. This can be true, my lord, about every product. Just to give an example, my lord, in case of, my lord, say defense industry, one of the scheduled industries. So suddenly the defense equipments manufacturing demand rises for any international reason, my lord. There may be some minerals which are which go into the manufacturing of the explosive or something. I am giving a very, very broad and hypothetical example. Then the government can step in. Right now you do without licensing, free market, free economy, no licensing, you do whatever you want to do, you invest your money, let the country grow, let the economy grow. But in certain circumstances, you have to step in. That is.
Then in regard to industrial alcohol, is the government exercising its regulatory power?
Yes.
Today, the compulsory licensing for industrial alcohol is gone. All alcohol is gone.
There are some regulatory controls. Licensing is not required, but I will show, there are some regulatory controls. The reason is this.
Fair enough. Now you were actually last time when we stopped, you were looking at our the statutory provisions. So you showed us section 10.
Before that, would your lordship,
let's quickly run through the statutory provisions so we can make some headway then.
And my lord, I'll show, my lord, what. Lord, there is a biofuel policy, and ethanol is an element in the biofuel policy. It's a national project. And if that project succeeds, my lord, the dependence on other fuel would be substantially reduced. So, my lord, there is some kind of a regulation in national interest. Now, please see, my lord, I take your lordships, my lord, to the note. It's there, part of my original written submissions, my lord. But, my lord, before, as my lords have, my lord, been pleased to say, my lord, I'll just take your lordships to the end. Lordship, may give me only a minute, my lords. Your lordship, I was at section 11. I'll read only those sections which are relevant. My lord, first, kindly see section 10. And bear, my lord, one fact in mind, your lordships are not deciding only alcohol. That incidentally happens to be the fact of a case which is referred. This law which my lords in this 9-judge combination would lay down, will apply to all scheduled industries today and in future also if regulation is required. Therefore, my lord, I am assisting not, my lord, to win in an alcohol related matter, to assist your lordships fully, objectively. Lord, section 10(3), subsection 3. Where an industrial undertaking is registered under this section, there shall be issued to the owner of the undertaking of the or the central government, as the case may be, a certificate of registration containing the productive and I am not showing productive taking is registered under this section, there shall be issued to the owner of the undertaking of the or the central government, as the case may be, a certificate of registration containing the productive capacity. Well, production comes here. That's the reason I am not showing productive capacity of the industrial undertaking and such other particulars. Not 4 last 2 lines also, productive capacity of the industrial undertaking and other prescribed particulars. Not suppose some commodity from the scheduled industry is now brought under licensing regime for some good reason, my lord, subject to your lordship's judicial review if challenged. Then, my lord, this will be done. Then 5. In specifying the productive capacity in any certificate of registration issued under subsection 3, the central government shall take into consideration the productive or installed capacity of the industrial undertaking as specified in the application for registration made under subsection 1, the level of production immediately before the date on which the application for registration was made under subsection 1, the level of highest annual production during the 3 years immediately, etc., etc. So, production is a part of IRDA, yes, which undisputably traces its origin to entry 52, list 1, read with entry 33, list 3. Lord, why I say this? Tikaramji says industry in 52 is confined only to manufacturing. After taking note of the act itself, I'll show how Tikaramji is either bad or is obiter.
Apart from 10.3 and 10.5, what is the other provision?
11.2. I have marked my copy. I will not read anything which is irrelevant.
Right.
11.2. A license or permission under subsection 1 may contain such conditions, including in particular conditions as to the location of the undertaking and the minimum standards in respect of size to be provided therein, as the central government may deem fit to impose in accordance with rules. In future, this contingency might arise with regard to some of the scheduled industries. Therefore, this provision. Then 11A, your lordships have seen license for producing or manufacturing new articles. But please see, my lord, 11B, power of central government to specify, my lord, I'm sorry, my lord, one more fact. While going through this, my lord, kindly bear one fact in mind, because that would be necessary when I assist your lordships on the question of repugnancy between the state provision and the central provision. Lord, one of the condition, one of the ground on which your lordship would test repugnancy would be that is the central act intending to cover the entire field of the subject? If the entire field is occupied by the central law. That would be one of the considerations. My lord, the Chief Justice in forum has, my lord, analyzed that. And my lord, I'll cite that judgment and one or two judgment on that. So that is one more reason why your lordships may see this act in totality, that it occupies it intends to occupy the entire field. They may use it, they may not use it. Then 11B, power of the central government to specify the requirements which shall be complied with by small-scale industries, industrial undertakings. Well, this is what my Lord Justice Roy, my Lord, was saying 29B. Small industries, those three conditions. Rest, Lord A, promoting in a harmonious manner the industrial economy of the country and easing the problem of unemployment. Then B, securing that the ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, in some contingency in future, like COVID, so this power may have to be invoked. That includes, my lord, control over the raw material also, because that's one of the natural resource or natural, my lord, ownership of the nation as a whole. I may be, my lord, producing, but ultimately it has to be harmoniously and uniformly distributed for the advantage of everyone. Then, my lord, kindly see subsection 2D. The nature, it covers every answer.
Yes.
It covers every aspect of industry. 2D, 11B, subsection 2, subclause D. The nature, cost and quality of the product of the industrial undertaking. This is also controlled.
In regard to small scale industries.
Yes. I'm just saying that
All right. What apart from this? What else?
Lord, 13D. Further provision for licensing of industrial undertaking in special cases. Effect any substantial expansion of an industrial undertaking which has been registered, etc. My lord, please see the explanation. Substantial explanation. Substantial expansion means the expansion of an existing industrial undertaking which substantially increases the productive capacity of the undertaking, or which is of such a nature as to amount virtually to a new industrial undertaking but does not include any such expansion as in normal undertaking having regard to its nature, etc. The government in a fact situation can say, expand your industry, expand your manufacturing capacity. The way, my lord, we did in oxygen. Now, my lord, 15. This is, my lord, again to show that the entire spectrum of every part of industrial activity is occupied by the central law, which is completely missed by Tikaramji judgment. Power to cause investigation to be made into scheduled industries or industrial undertakings, where the central government is of the opinion that A1, there has been or likely to be substantial fall in the volume of production in respect of any article or class of articles relatable to that industry. So please, not just the product. When I say sugar cane, which is the raw material, is also relatable to the industry. Production in respect of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings, as the case may be, for which, having regard to the economic conditions prevailing, there is no justification. Well, the government can invoke 15 and say that why suddenly sugar production has gone down? Why suddenly non-potable alcohol production has gone down? Because it is necessary considering the economic condition of that.
Right, which are the other provisions? Let's quickly run through them.
I'm sorry, Manoj. But I'll not take your lordship. So anything irrelevant which is not read, I'll read.
Yes, yes.
2. There has been or is likely to be marked a deterioration in the quality of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertaking as the case may be. Then 3, there has been or is likely to be a rise in prices of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings as the case may be. And 4, it is necessary to take any such action as is provided in this chapter for the purpose of conserving any resources of national importance which are utilized in the industry or the industrial undertaking or undertakings as the case may be. Then, my lords, may kindly come to 16. For powers of the central government on completion of investigation. Then A, power is to regulate the production of any article or class of articles by the industrial undertaking or undertakings and fixing the standard of production. Then C, B I am skipping, C, prohibiting the industrial undertaking or undertakings from resorting to any act or practice which might reduce its or their production capacity or economic value. Lord, suppose we need industrial alcohol for sanitizer and majority of the industrial alcohol goes for manufacturing of potable intoxicating liquor. The government can step in and say that circumstances exist that we give up our forbearance, we step in and we exercise this power. Controlling the prices or regulating the distribution of any article or class of articles which have been the subject matter of investigation. My lord, now price control is, my lord, your lordships may mark entry 34, list 3. Then your lordships have, my lord, seen 18. My lord, several provisions. I am not. I don't intend to read them, my lord. Please come to 18G. This is the only provision which is considered. Page 577, my lord, your lordship, of volume 4. Your lordships have that? May I read?
Yeah.
Power to control supply, distribution, price, etc. of certain articles. The central government, so far as it appears to it to be necessary or expedient, for securing equitable distribution and availability at fair prices. This is the condition. Which condition may arise in future, even with regard to scheduled industries which are today exempted.
Yes.
Please go further, my lord. At fair prices or any article or class of articles relatable to any scheduled industry. But the relatable means raw material also. The only condition is that it should be formation of an opinion that it is required for securing a equitable distribution and availability at the fair prices at a national level. So not only the production, the price, the quality, the manufacturing activity, but even related products also can be regulated. Scheduled industry may, notwithstanding anything contained in any other provisions of this Act, by notified order. So this is one contention which I will separately deal with in a very short span. Notified order provide for regulating the supply and distribution thereof and trade and commerce therein. All of the expressions under 33, list 3, 33. Then without prejudice to the generality of the powers conferred by subsection 1, a notified order made thereunder may provide A, for controlling the prices at which any such article or class thereof may be bought or sold. Price control. Then, my lord, C, prohibiting the withholding from sale of any such article or class thereof ordinarily kept for sale. Then D. And D is relevant, my lord, even for the purpose of answering that notified order question, my lord. For requiring any person manufacturing, producing, or holding in stock any such article or class thereof to sell the whole or part of the article so manufactured or produced during a specified period. So notified order can be for a specified period also. The power before that date and after that specified date still remains. Or to sell the whole or a part of the article so held in stock to such person or class of persons and in such circumstances as may be specified in the order. Then E, for regulating or prohibiting any class of commercial or financial transactions. See the width of the act, my lord. It occupies the field totally. Or for regulating or prohibiting any class of commercial or financial transactions relating to such article or class thereof, which in the opinion of the authority making the order are, or if unregulated are likely to be detrimental to public interest. Even this can be done if public interest requires. It would normally not be done. That is forbearance. When it is done by way of a notified order. But the power remains.
The fact with the forbearance, really, that's the point which you will have to meet, which is that today, except for 4 industries, cigarettes, electronic aerospace, industrial explosives, and hazardous chemicals, all other industries have been exempt from the provisions of the statute. The power under section 29B has been utilized, you said. So theoretically speaking, the government, of course, the authority which issues an exemption can withdraw it. There's nothing to prevent the government from again withdrawing the exemption for 1 or more industries. Today, as the position stands, industrial alcohol per se stands exempted from the provisions of the Act, right? Now, in a theoretical future, the government can, of course, withdraw the exemption if it sees, as you rightly said, suppose, there's a COVID-like situation arose, and hopefully we hope it will never again arise. But
yes, anywhere in the world.
Yes. Anywhere in the world. But as you said that, you required sanitizers, therefore you had to control the production of alcohol used for sanitizers. Fair enough. But if the government has, as of a given point of time, exempted an industry completely from the operation of the Act, right? So as to obviate any exercise of the power under section 18G at that time, then other states
or other provisions, or other
states then denuded of the power to regulate that industry.
I'll my lord. I'll just point out, my lord.
The exemption from the provisions of the statute covers everything or only licensing?
Only licensing, not section 2. Section 2, which is a declaration under entry 52. I just read, your lordship need not open. Section 2 of the IDRA, declaration as to expediency of control by union. It is hereby declared that it is expedient in public interest that union should take under its control the industries specified in the first schedule. This is not exempted. This operates. The regime of licensing is under the forbearance. But otherwise, what happens? And whether, my lord, I'm posing a question to myself, your lordships would interpret it in that manner that this is the result. What happens if your lordships were to say that so long as there is a notified order, the state would be denuded of its powers? If there is no notified order and we are in a forbearance, we means the central government is in a forbearance regime, they would have the power. My lord, the question I'm posing to myself is, my lord, can that be the jurisdictional ping pong? That if I interfere, they may have a law that would stop from operating because now there is a notified order. The moment I withdraw that notified order, they again either bring new law or their earlier law becomes operating. That's not the intention. Therefore, my lord, my lord, at the outset said that what is relevant is, does this act occupy or intends to occupy entire field or not? It occupies, my lord, right from raw material, pricing, quality, production, lack of production, investigation, manufacturing, final goods, finished products, sale. Everything is, my lord, occupied. And once there is a law, my lord, there is a judgment which says that even a non-operative law, if it occupies the field and if it's a central law, the state government is denuded. My lord, that I read that judgment, my lord. What happened was that, my lord, in that judgment, I'll come to that, my lord, little later. My lord, the question was, the central government brought a law. The parliament made a law. It gave it was assented to by the President of India.
Yes.
My lord, the law provided that it shall come into force from such date as the central government may appoint. Every law provides. That was not done. And there was a state law, and the argument on behalf of the state was that since the law made by parliament is not brought into force, there is no question of repugnancy. Repugnancy with what? This court rejected that argument, saying that what Article 254 contemplates is law made by the parliament, not law in force. If there is a law made by the parliament and if the field is occupied, then the state is denuded. But I'll come to that judgment, my lord.
Yes.
But you have to answer this question of the other side, that entry 8 is outside, entry 8 list 2 is outside the scope of entry 24 of list 2.
That's a separate, my lord. Yes, I will have to answer that. I will, my lord, I'll immediately after that, my lord, I'll come on that. I'm just, my lord, trying to show that the Central Act occupies the field and intends to occupy the field because that
From 18G?
22. So there is a development council contemplated, my lord, which
Okay, that's a direction to the development council.
development. No, yes. My lord, please see 25. 26. Power to issue directions. The central government may give directions to any state government as to carrying into execution in the state of any of the provisions of this act. But completely supervening legislation. And last, your lordships may see, Not 31 also, but I must show your lordship fully. Application of other laws not barred. The provisions of this act shall be in addition to and not save as otherwise expressly provided in this act in derogation of any other central act for the time being in force. The state act is barred. But when I read the judgments on repugnancy, and there are only 3 judgments which I'll read, so this would be relevant. When I'll be able, I would attempt to satisfy your lordships that there is a legislative intent to occupy the field fully and completely. Now, your Lordship will only see as a last point on IRDF. Very quickly, please come to Malord. I'll complete this within 10 minutes. The history of Malord, this act, Malord, how alcohol is dealt with, Malord. That is at page 56 of my written submissions, Malord, 2D, volume 2D. I'll read only the Malord, title, not read, Malord, the whole thing. Because, my Lord, the Chief Justice's question whether alcohol is right now under regulated category or not, but some part of it is therefore. The second purpose of showing the history is six 56 of my written submissions, my Lord. Volume 2D, 2 capital D, D for Delhi. The purpose is, Manoj, it has always remained with the center, historically. Manoj, Indian Power Alcohol Act used to govern 1948. Then comes, Manoj, Indian Power Alcohol Amendment. I'm sorry. Manoj, Indian Power Alcohol Act used to govern, page 56, Manoj. Then 57, Indian Power Alcohol Amendment Act came into force. Then central government constituted alcohol committee in 1956. Then this order came to be passed under 18G of IDRA. Ethyl alcohol.
Now, if that is so, denatured spirit, or what we loosely call industrial alcohol, we'll call it denatured spirit, is not within the ambit of entry 8 of list 2. 2. If denatured spirit is not within the ambit of entry 8 of list 2, this is not what you said, but I'm just putting it. It would otherwise have been within the fold of entry 24 of list 2.
That is true.
Right? One second. It would have been within the ambit of entry 24 of list 2, which is the provision relating to industry.
The correspond not only here, but earlier also, whenever Tikaramji was followed, only 2 or 3 paragraphs were cited out of context.